It is an offence under Section 139 of the Criminal Justice Act 1988 to be in possession of a blade or sharply pointed article in a public place without a good reason, unless, of course, it comes within the exemption of a folding pocket knife. That's what I'm talking about in this video, so welcome back. I am the Black Belt Barrister, helping you to understand law. The usual and fairly broad defence to this is that you have a good reason, and this is provided by subsection 4 under Section 139. One such example of a good reason might be that you use this knife as a tool for work, and you are on the way to work, or you're on the way back from work. What I would recommend, however, is that you don't simply have the knife in your pocket, but you remember to put it back in your tool bag, and the bag is stored in the back of your van, away from your immediate reach, so that it can't be argued that you've got this in your pocket for any other reason. And this is a key point, because the burden is upon the defence not just to provide an explanation as to why you have the knife, but to provide it as a very good reason. And this will come under strict scrutiny by way of cross-examination if you were to be prosecuted for being in possession of the knife and it's said that you don't have it with a good reason. One such example of when this might happen is if you are being accused of being involved in some other kind of offence and you happen to have the weapon with you, and you've said that your good reason is that you use it for work and you're on the way to or from work. But if you get caught up in something else, for example road rage, and the knife is in your pocket, then there's going to be an argument that you've not got the knife with you for a good reason. Because the good reason may well fall away if you are standing in the middle of the street arguing with somebody and the argument is put to you that the knife should have been in your tool bag. And of course this would be right from a sensible assessment of the facts in question. If the knife is in your pocket and you're standing in the street arguing with somebody, that can detract from it being a good reason when it might well have been a good reason otherwise. Other types of good reason might be that you're using it for some kind of demonstration. For example, martial artists will take some kind of bladed article to and from demonstrations or training seminars and things of this nature, or if it's being transported to or from or between museums or other kind of exhibitions and things like this. One of the discussions that comes up very often is that in subsection 2, that is the folding pocket knife exemption. The exemption in short is that it must be immediately foldable at all times and the blade must not exceed 3 inches. It must also not have any kind of slogans on it, serrated edges and things of this nature. Many people, with respect, mistakenly argue that if the overall length of the blade is longer than 3 inches but only the sharp portion is 3 inches, then it still comes within the folding knife exception. But this is not exactly true. The court has held before that even a butter knife which doesn't have a sharp edge is still considered a bladed article for the purposes of the Act. Therefore, whether or not the blade is sharp or not doesn't matter. And the court in fact said if we were to invite argument in case after case as to whether or not the edge of the blade was sharp, then we would be inviting great mischief into each case. So remember, if you are carrying a folding pocket knife and you are hoping that it comes within this exemption, it must be immediately foldable at all times, which means it must not have any kind of locking mechanism whatsoever that prevents it from closing. I know many people have said that this actually makes for a dangerous knife, but the point of the Act is to restrict knives that can use a lot of force, and only a folding pocket knife for very minimal purposes can be carried within this exemption. Also, please don't get confused with the length of the blade. It is a maximum length of 3 inches. It must not be more than 3 inches, regardless of whether or not the blade is sharp or not. And so even if the full length of the blade is not sharp, but it is longer than 3 inches, even if it's still foldable, it will still be a bladed article for the purposes of the Act. Also, please remember that flick knives and switch blades and any other blade that comes out with the press of a button, and that includes gravity knives and butterfly knives, they do not come within the exemption of a folding pocket knife. In fact, it is important for you to know that these kind of knives are in fact banned for import into the UK, possession, sale and hire, lending or even giving someone one of these knives, unless of course some other kind of exemption applies. And so these banned knives include butterfly knives, which are also known as balisongs, which is a handle that splits in two to reveal the blade in the middle, disguised knives, which is a blade or a sharp point hidden inside something that looks like any other everyday object. For example, a buckle, a phone, a brush, lipstick that has a blade inside that's been disguised. These are outright banned. Also, flick knives, which are commonly known as switch blades or automatic knives. These are where the blade opens or comes out at the press of a button automatically, or even gravity knives. That's where with the flick of the wrist, the blade comes out. These are also banned knives. The same goes for stealth knives, which is a non-metal knife, or a spike, which is not made for use at the home, for food, and is not a toy. Also banned are zombie knives. This is with a knife with a cutting edge or a serrated edge that's got images or words suggesting that it's being used for some kind of violence. There is a full list of knives and weapons that are banned in the UK, and I'll put a link to those in the description below. Remember, for swords, there are still exemptions for those that are antiques or those that are made to traditional methods or before 1954. So if you are buying any of those, again, please do check that they are made in a traditional method and that they are not subject to this ban. And as another fairly broad piece of guidance that I will give you, regardless of what knife that you are carrying around and whether or not you have a good reason for carrying it, you must not be carrying it for the purposes of self-defense or for the purposes of using it to harm someone else. Merely carrying any kind of object, whether it's a knife or not, for those kind of purposes, in other words, the purpose to cause someone else harm, will make this item an offensive weapon. Therefore, if you are unfortunately caught up in the situation where you need to defend yourself and you have an item that you are using, if you were to tell the police officer that you are carrying it around for the purposes of harming someone else or for the purposes of self-defense, which ultimately might amount to the same thing, then this might be taken as an offensive weapon and it may harm your chances of successfully arguing that you are acting in self-defense. So that brings me on to the fairly broad topic of offensive weapons, and there are broadly three types of offensive weapons. Firstly, those that are made to cause harm. Secondly, those that have been adapted to cause harm. And thirdly, those that you are carrying with the intention of causing harm. And it's this third category that many people get caught out by. The first category is fairly obvious. Some kind of truncheon or something like that is clearly made to cause harm. For the second category, those that have been adapted to cause harm, a simple example might be a glass bottle, whereas in every other situation it is just a glass bottle. But if it's been broken for the intention of causing a serrated edge, which will cause somebody harm, then it's been adapted to be an offensive weapon. The third kind, as I said, is one that many people get caught out on, and that is an object which is being carried around for the purposes of causing someone else harm. It is the intent of carrying the object around that makes this an offensive weapon. Now, this doesn't necessarily mean you can't use anything else to defend yourself that you happen to be carrying with you, but you simply cannot carry it with the intent in the first instance for causing harm. This is going to make it an offensive weapon. So if you find yourself on websites that are selling what look like everyday objects, but they conceal a spike or they conceal a knife, or even it is just the object itself, but it has spikes on the corner, but it's quite clear that the website is selling them to be an offensive weapon of some kind, even if they are made to look like some kind of jewellery, I would suggest against carrying those, simply because if it is obvious that the website is selling them for a self-defense weapon, you are going to struggle when it comes to arguing self-defense, because this is ultimately going to be an offensive weapon. And as a final word of warning, if you are carrying any kind of knife around with you, avoid places that are obvious restrictions such as schools, airports, courts, and places like this. If you do happen to be going to, for example, a court and you've forgotten that you've got some kind of bladed article in your pocket, such as nail clippers that has a little blade that comes out of it, just be honest with the court staff, tell them that you've got it, you mean no harm with it, but hand it in immediately. Don't just leave it to be found and then confiscated, because that's obviously going to look bad. Court staff will usually be quite sensible about taking it into safe possession for you, presuming that it is a legal item in the first place, but it's obviously better that you are upfront about it rather than it's found during a search. So if this has been a useful reminder for you, please give it a thumbs up, make sure you subscribe, and I'll see you next time.